I would say somewhat prejudiced, not unprejudiced. Hello, everyone. It is great to be back. It is wonderful to talk. You mentioned the sort of where are they now. Forgive a small, I begin with a small digression. I am just back from Los Angeles where they are shooting a mini-series, I'm thrilled to say, for the FX network that is based on my book about the O.J. Simpson case, the run of his life. And John Travolta plays Robert Shapiro. Cuba Gooding is O.J. Simpson. Courtney Vance is Johnny Cochran. David Schwimmer from Friends is Robert Kardashian. I mean, it is so exciting. I can't tell you. And I actually, they gave me a cameo yesterday where I sat in the audience, and they are being so meticulous that they had to put a very ugly 90s suit on me with like the big lapels and the really ugly tie. And so it was just, just starting to worry about whether people remember the O.J. Simpson case, people know it. I'm now actually writing a book about the kidnapping of Patricia Hearst, which is before everybody's time, in 1974. It's actually what you mentioned, John Dean. One of the things that's going on at the exact same time at the kidnapping of Hearst is the denouement of Watergate. She's kidnapped in February of '74, and Nixon resigns in August of '74. So if you have any questions about the O.J. Simpson case or the Patricia Hearst kidnapping, feel free to ask them as well. But I am going to talk about the sort of the last term of the Supreme Court and where things are going. And since this is somewhat of an informal event and this is not a cast of thousands, I mean, I'm intentionally leaving time at the end for questions. But if, as I am talking, a question occurs to you, please just pipe up. I mean, this is not, you're a bunch of lawyers, you got a lot on your, you know about these issues as well as I do, and I'm very happy to sort of interrupt and talk about it as we go. So I'd like to talk about the Supreme Court by the numbers first. So as you know, there are 6 men and 3 women. First time in history, there are 3 women on the court. There are 6 Catholics and 3 Jews. There are no Protestants on the Supreme Court. Also the first time in history, there are no Protestants. There are representatives of 4 New York City boroughs on the Supreme Court. Antonin Scalia is from Queens, Ruth Ginsburg's from Brooklyn, Sonia Sotomayor is from the Bronx, and Elena Kagan is from Manhattan. Tragically, Staten Island is unrepresented on the Supreme Court, and so we can only hope future appointments address that gap. Anyway, so those are some facts about the Supreme Court, but here is, and I think I hope they are interesting facts, but here is a important fact about the Supreme Court. There are 5 Republicans and 4 Democrats. Now, if I leave you with any message at all, I can tell you that that is the single most important fact about the Supreme Court, because we live in a moment where political polarization, very much along party lines, is, I think, the dominant fact about our political life at the moment. Never have the parties been farther apart on more issues than they are now. And to me, the most significant development of my lifetime is the evolution of the Republican Party, and that is particularly evident at the Supreme Court, because the Supreme Court, for decades, has been dominated by moderate Republicans, whether it was John Marshall Harlan in the 50s, or Potter Stewart in the 60s, or Lewis Powell in the 70s, or Sandra Day O'Connor in the 80s and 90s. They're all gone. They're all gone from the court. They're all gone from the Senate. They're all gone from the House of Representatives. When I started following politics, there was this enormous core of liberal Republicans in the United States Senate, whether it was Robert Stafford in Vermont, or Chafee in Rhode Island, or Packwood and Hatfield in Oregon, and Chuck Percy in Illinois. They're all gone. Arguably Susan Collins of Maine is the last moderate Republican in the Senate, and they are also gone from the United States Supreme Court. Now, we'll get to that. Well, Anthony Kennedy is a special case, and we will get to him in a moment. But in terms of this past Supreme Court term, I'd like to talk first about a case that is probably not all that familiar to you. We'll get to the more familiar cases. But it's, and I don't mean to make this a quiz or anything, but if I said to you, Reed versus Town of Gilbert, anybody know that case? You do know the case? Yeah, not many people do, but some people do. Anyway, it's a really interesting case just on its own terms, but I think it tells you something about where the court is on the First Amendment that is just enormously important, and I think even potentially useful for you people who are actually litigators, particularly often in a corporate context, that a very dramatic thing is going on regarding the First Amendment at the Supreme Court. Okay, so let me just tell you about what the facts of Reed versus Town of Gilbert were. It was a case about a regulation in a town in Arizona about regulation of outdoor signs. A lot of towns tell you how many, what kind of signs you can regulate. And bear with me here for a second because it's a little complicated, but they basically said you couldn't have any signs without a permit. But there were 23 exceptions. And three of the exceptions were ideological signs, defined as signs communicating a message or ideas that could be displayed, political signs designed to influence the outcome of an election, which could be up for a certain period of time around Election Day, and a third category, temporary directional signs, such as signs saying, go to the church fair, but they could only be up for no more than 12 hours before the event. So there were these exceptions. And a church which wanted to keep its signs up for longer than 12 hours sued and said this regulation was a violation of the First Amendment. And they won. They won 9-0. But there was a huge dispute within the court about what the rationale was. And Justice Thomas wrote the majority opinion for the court. And what he said was that whenever there is any sort of regulation of content, there has to be strict scrutiny, and the government has to come up, in effect, with a really, really good justification. And they failed to come up with a legitimate justification here for such a tight limit on these directional signs, and so the statute was unconstitutional. Well, what that really means is that the definition of content is so broad that it has raised the question of whether any regulation of signs is possible. And Justice Kagan, who was joined by Breyer and Ginsburg, wrote an opinion concurring in the judgment, and she began it by saying, countless cities and towns across America have adopted ordinances regulating the posting of signs while exempting certain categories of signs based on their subject matter. And she pointed to examples that said you could have a lot of towns ban illuminated signs, but you can have an illuminated sign at your own residence. In other municipalities, safety signs such as blind pedestrian crossing or hidden driveway can be posted without a permit, even if other permanent signs require a permit. Historic site markers, like George Washington slept here, are also exempt from many regulations. So what she was saying is there are lots of content-based regulations of signs, and we don't want to tell towns that they can't do what they have always done. And what I think this tells you is that this court has an almost Pavlovian response, affirmative response, to First Amendment claims based on claims that it regulates, that content is regulated. And I'll give you an example from the D.C. Circuit, which shows you how this is all playing out in the lower courts. This is a case involving POM, the pomegranate juice, you know, that stuff, and you know, which like, they put stuff on the label that suggests it's good for you, and it's not. And the FTC had an order said that anything requiring health claims used in marketing foods